Mitigating circumstances, Article 13 of the RPC, Part 6. Prior to the enactment of Republic Act No. 9346 prohibiting the imposition of the death penalty, there were two cases where the fact that the offender is over 70 years of age had the effect of a privilege mitigating circumstance, namely 1. When he committed an offense punishable by death, that penalty shall not be imposed, Article 47, Paragraph 1, and 2. When the death sentence is already imposed, it shall be suspended and commuted. Article 83. In any of the above-mentioned two cases, the penalty of death will have to be lowered to life imprisonment, reclusion perpetua. Basis of Paragraph 2. The mitigating circumstances in Paragraph 2 of Article 13 are based on the diminution of intelligence, a condition of voluntariness. Paragraph 3. That the offender had no intention to commit so grave a wrong as that committed. Rule for the application of this paragraph. This circumstance can be taken into account only when the facts proven show that there is a notable and evident disproportion between the means employed to execute the criminal act and its consequences. U.S. v. Reyes. Illustrations. 1. The husband who was quarreling with his wife punched her in the abdomen, causing the rupture of her hypertrophied spleen, from which she died. People v. Rabayo. 2. The accused confined himself to giving a single blow with a bolo on the right arm of the victim and did not repeat the blow. The death of the victim was due to neglect and the lack of medical treatment, his death having resulted from hemorrhage which those who attended to him did not know how to stop or control in time. U.S. v. Bertuccio. 3. The accused, a policeman, boxed the deceased, a detention prisoner, inside the jail. As a consequence of the fistic blows, the deceased collapsed on the floor. The accused stepped on the prostrate body and left. After a while, he returned with a bottle, poured its contents on the recumbent body of the deceased, ignited it with a match and left the cell again. As a consequence, the victim later on died. Held, the accused is entitled to the mitigating circumstance of no intention to commit so grave a wrong as that committed. People v. Ural. Intention, being an internal state, must be judged by external acts. The intention, as an internal act, is judged not only by the proportion of the means employed by him to the evil produced by his act, but also by the fact that the blow was or was not aimed at a vital part of the body. Thus, it may be deduced from the proven facts that the accused had no intent to kill the victim, his design being only to maltreat him, such that when he realized the fearful consequences of his felonious act, he allowed the victim to secure medical treatment at the municipal dispensary. People v. Ural. Thus, where the accused fired a loaded revolver at the deceased and killed him, it must be presumed, taking into consideration the means employed as being sufficient to produce the evil which resulted, that he intended the natural consequence of his act and he is, therefore, not entitled to the benefit of the mitigating circumstance of lack of intention to commit a wrong as that committed. U.S. v. Fitzgerald. Thus, where at the time of the commission of the crime, the accused was 32 years of age, while his victim was 25 years his senior, and when the latter resisted his attempt to rape her by biting and scratching him, to subdue her, the accused boxed her and then held her on the neck and pressed it down. While she was lying on her back and he was on top of her, these acts were reasonably sufficient to produce the result that they actually produced the death of the victim. People versus Umit. So also, when the assailant, armed with a bolo, inflicted upon his victim a serious and fatal wound in the abdomen, it is not to be believed that he had no intention of killing his victim. Having clearly shown, by the location of the wound, that he had a definite and perverse intention of producing the injury which resulted. U.S. vs. Mendak. Defendant alleged as mitigating circumstance that he did not intend to commit so grave an injury. Held, the plea is groundless, he used a knife 6 inches long. The fatal injury was the natural and almost inevitable consequence. Moreover, he attempted to stab a second time but was prevented from doing so. People vs. Orangan, et al. The weapon used, the part of the body injured, the injury inflicted, and the manner it is inflicted may show that the accused intended the wrong committed. One intention must be judged by considering the weapon used, the injury inflicted, and his attitude of the mind when the accused attacked the deceased. Thus, when the accused used a heavy club in attacking the deceased whom he followed some distance, without giving him an opportunity to defend himself, it is to be believed that he intended to do exactly what he did and must be held responsible for the result, without the benefit of this mitigating circumstance. People vs. Flores. 2. When a person stabs another with a lethal weapon such as a fan knife, and the same could be said of the butt of a rifle, upon a part of the body, for example, the head, chest, or stomach, death could reasonably be anticipated and the accused must be presumed to have intended the natural consequence of his wrongful act. People vs. Reyes, People vs. Dadu Baganda. 3. The weapon used, the force of the blow, the spot where the blow was directed and landed, and the cold blood in which it was inflicted. All tend to negative any notion that the plan was anything less than to finish the intended victim. The accused in this case struck the victim with a hammer on the right forehead. People vs. Banlos. 4. As to the alleged lack of intent to commit so grave a wrong as that committed, the same cannot be appreciated. The clear intention of the accused to kill the deceased may be inferred from the fact that he used a deadly weapon and fired at the deceased almost point blank, thereby hitting him in the abdomen and causing death. People vs. Reyes. 5. Where the evidence shows that, if not all the persons who attacked the deceased, at least some of them, intended to cause his death by throwing at him stones of such size and weight as to cause, as in fact they caused, a fracture of his skull, and as the act of one or some of them is deemed to be the act of the others, there being sufficient proof of conspiracy. The mitigating circumstance of lack of intent to commit so grave a wrong as the one actually committed cannot favorably be considered. People vs. Bautista, People vs. Espejo. Inflicting of 5 stab wounds in rapid succession negates pretense of lack of intention to cause so serious an injury. The inflicting by the accused of 5 stab wounds caused in rapid succession brings forth in bold relief the intention of the accused to snuff out the life of the deceased, and definitely negates any pretense of lack of intention to cause so serious an injury. People vs. Brna. Article 13,